All right, good morning, everyone. Welcome to the appellate court. I'm Judge Bright. I'm sitting this morning with Judge Mull and Judge Clark on the matter of STEELE versus the Commissioner of Correction. AC docket number is 43903. This argument is being conducted over the Teams platform, so everyone is appearing by video conference. The matter is also being streamed live on the branch's YouTube channel. I would remind everybody that to the extent there's any protected information involved in this case, that we all be careful not to disclose any of that protected information. I'm going to ask everyone to introduce themselves to make sure we can all see and hear each other okay. I'll start with the judges, then counsel for the appellant, then counsel for the appellee. Again, I'm Judge Bright.
I'm Judge Mull. Good morning.
Judge Clark, good morning.
James Mortimer for the petitioner.
Rocco Trenza on behalf of the Commissioner of Correction.
All right, I can hear and see everyone okay. I assume that's true for everybody else. If at any time you are unable to hear anyone, please let us know. If you are unable to see anyone, please let us know. And if you get disconnected from the video conference for whatever reason, please go back to the link and log back on. We will suspend the argument until everyone is present. We're going to ask everyone to keep their microphones muted during the argument, except when you're talking. That will help cut down on the background noise. We would ask everyone to keep their cameras on at all times so we can make sure everyone is present and appropriately engaged in the argument. And I will remind everyone that although we are all in separate locations and not in the courtroom, this is a court proceeding and everyone should act accordingly as if we were at the physical courtroom at 75 Elm Street here in Hartford. The judges are going to raise their hands if they have questions. I would ask counsel to recognize them. Again, we're trying to avoid talking over each other and cutting down on the background noise. Each side will have 20 minutes to argue. The appellant can reserve some time for rebuttal. I am going to keep the time here, and because we do not have our light system available to us, I will hold up a sign at 2 minutes, at 1 minute, and when the time is up. So with that, I believe we're ready to go. Attorney Mortimer, are you ready to proceed?
Yes, Your Honor.
How much time would you like to reserve for rebuttal?
May I please reserve 5 minutes for rebuttal, Your Honor?
Yes, you may proceed.
Good morning, Your Honors. With respect to the instant habeas appeal, there is one issue presently being, well, two issues being prosecuted in this appeal, the foremost of which is that the habeas court erred in denying the petitioner's ineffective assistance of counsel claim on the merits. And that's specifically with respect to a claim the petitioner prosecuted below concerning trial counsel's failure to introduce what he submitted as exculpatory DNA evidence that was prepared by the lab in conjunction with an FBI investigation into a bank robbery. Now, what the evidence revealed in the underlying habeas trial was that trial counsel had developed a strategy of effectively locking in Special Agent McNamara, who was an FBI agent that did some investigation in this case, into testifying that the DNA evidence collected in this case, and there was quite a bit of DNA evidence that was collected, none of it pointed to the petitioner. So this is with respect to swappings taken from an airsoft BB gun that was recovered, purportedly thrown from the vehicle used in the robbery off of Route 8 in Shelton, that coincidentally, at that same time that gun was airsoft gun was ejected from the vehicle, the bank manager from the bank that had been robbed was simultaneously driving down Route 8 and caught sight of that gun being thrown. Now, the swabbings taken from that pellet gun exclude the petitioner as a contributor. There was a mixture of DNA located on that airsoft gun, including other males. So by virtue of trial counsel's failure to introduce this evidence or even lock in Special Agent McNamara into the fact that the petitioner's DNA was not collected in conjunction with this investigation, we submit that he was prejudiced. So the habeas court made one determination with respect to this issue and made no findings as to deficient performance, but instead assumed the same, that the petitioner wasn't prejudiced in light of what the habeas court characterized as overwhelming evidence against him. So with respect to that evidence, it's our position in this appeal that although the state concededly did have a strong case against the petitioner, we would submit that it wasn't so overwhelming as to the petitioner not having been prejudiced by trial counsel's failure to introduce this DNA information to the jury. The underlying defense theory, in fact, was that another individual named Orville Eady had committed the robbery, and the petitioner's counsel attempted to point the finger at Mr. Eady throughout the course of the underlying trial. Now, we don't know whether or not the DNA that was actually tested would have implicated Mr. Eady because it was run against the petitioner's DNA, according to these reports. However, the mere fact that other individuals' males' DNA were locus in samples were located in a mask, the gun, as well as gloves, would have been helpful for the defense in terms of pointing the finger at someone other than the petitioner. And in support of the finding that the petitioner wasn't prejudiced, the habeas court did accord quite a bit of weight on evidence that was found in a car, in the Cadillac that was allegedly used in the robbery, including gloves that had matched the characteristics of or shared characteristics of those worn during the course of the robbery. However, that evidence the petitioner would submit is not quite so damning because it was the defense's theory that Mr. Eady had actually utilized the Cadillac during the commission of the offense. And similarly, with respect to a purported admission that the petitioner had allegedly made prior to his trial to a friend, we would submit that there were significant credibility issues with respect to that individual's testimony. Namely, Ms. Clark had a pending larceny case at the time. She was admittedly believed that she was on drugs on the day of the robbery. She had indicated that an FBI agent had attempted to bribe her in order to gain her cooperation. So overall, we would submit that the evidence was not quite so damning as to not having caused the petitioner to have been prejudiced by this failure of trial counsel. Trial counsel offered no strategic reason for not introducing this evidence and in fact had indicated that it was his intent to demonstrate to the jury that the defendant's DNA was not associated with any of the evidence that was collected, and he just simply failed to do so. Now, with respect to the habeas court's determination, the habeas court had also determined that this appeal didn't merit review in denying the petitioner's petition for certification. We would also submit that the habeas court abused its discretion with respect to that determination.
Attorney Mortimer?
Yes, Judge.
During the criminal trial, did counsel argue to the jury that the state had presented no evidence of the petitioner's DNA?
The petitioner's underlying counsel did not make that argument to my recollection. The essence of closing argument by trial counsel was effectively that Mr. Eady had been the person that committed the offense, and this is why the evidence was found in the petitioner's car, that there was evidence that Mr. Eady and the petitioner had engaged in financial transactions in the past, and that's how the petitioner came into the possession of dye-stained money when he was ultimately apprehended. And there was some evidence indicating that Mr. Eady had used the petitioner's car in the past as well. However, as to the issue of DNA, there was a deafening silence.
And the respondent argues in his brief that even if there was some prejudice as to the robbery charge, it would not affect the conspiracy charge. Do you agree with that?
The petitioner would concede that, Your Honor, in terms of the conspiracy charge. Yes, Your Honor.
Okay, thank you.
Attorney Mortimer, could I ask a question as you're transitioning? Can you summarize the evidence with regard to law enforcement's confirmation that Mr. Eady was in fact at Bridgeport Hospital visiting his child on the morning in question?
Effectively, Mr. Eady had a pass from Bridgeport Hospital, and aside from that pass, Mr. Eady testified as well that he had been at Bridgeport Hospital at the time of the offense. However, the petitioner's position during the underlying criminal trial was that that was a farce, and that Mr. Eady would have had conceivably enough time also to have engaged in this robbery. There was quite a wide window of time from the time that he had gone to Bridgeport Hospital.
All right, I thought there had been a representation in one of the briefs that law enforcement had confirmed that Mr. Eady had in fact gone to Bridgeport Hospital at the time when this was, when the robbery was occurring at Webster Bank. Is that not correct?
Well, to the extent that Mr. Eady had indicated that he was at Bridgeport Hospital and had a pass for Bridgeport Hospital, to that extent, it was confirmed. But it would appear that there may have been enough time during that interim period for Mr. Eady to also have engaged in this conduct, although the window was fairly narrow.
All right.
So given the simplicity and narrowness of this issue, and in light of the extensive briefing done in this matter, the petitioner, unless there are additional questions, would respectfully reserve the rest of his time for rebuttal.
Okay, so you'll have 11 minutes left for rebuttal. Attorney Terenza, are you ready to proceed?
Yes, Your Honor. Good morning, Your Honors. Rocco Terenza, Assistant State's Attorney on behalf of the Commissioner of Correction. I'd like to begin by responding to Judge Mall's question regarding the evidence of police confirming Eady's whereabouts during the time of the robbery. I would direct Your Honors to the June 18th, 2014 transcript. It's titled the afternoon transcript at pages 22 and 23. Therein, the police testified that they contacted someone from the hospital and obtained confirmation that Mr. Eady had in fact checked in and checked out of the hospital, and as a result of that, eliminated him as a suspect in this crime. And so, to the extent the petitioner is still maintaining that Mr. Eady is the true culprit, I think the evidence in this case establishes that he failed to put on any evidence at the habeas trial to support his conclusion that Mr. Eady was in fact the culprit. In fact, all of the evidence that existed eliminated Mr. Eady as a potential suspect in this case. Again, the petitioner in a habeas action bears the burden of proving both prongs of the Strickland test. That is, that counsel rendered deficient performance and that he was in fact prejudiced, meaning that but for counsel's deficient performance, there's a reasonable probability that the outcome of the trial would have been different. Here, the petitioner failed to meet that burden. The evidence...
Attorney Terenza, was there testimony about the time that Mr. Eady checked out of the hospital?
Not from the police, as far as I recall. It was from Mr. Eady himself that his son was in and out of the hospital both on the Friday and the Saturday and wasn't discharged until late Saturday afternoon, I believe. And then he showed up, he went to the police department and met the police Saturday evening and still had his visitor pass visible on his clothing, both him and his wife. And so that, in conjunction with the fact that police actually contacted a member of the hospital and verified that he had checked in and checked out, and as a result eliminated him as a suspect, I think fully supports the conclusion that he was at the hospital during the course of the robbery. Again, the evidence against the petitioner was both overwhelming and varied throughout the course of this trial. It was undisputed that the petitioner purchased a Beretta-style BB gun on the morning of the robbery at Walmart. Despite that evidence, the petitioner at the habeas trial offered testimony that he was at another individual's house throughout the morning. He ultimately acknowledged that he purchased a BB gun, but claimed that he wasn't. He was at her, Lanzieri's house, up until 11 or 12 o'clock. He then claimed that he went back there and was there until dusk. However, at the underlying trial, the petitioner's cell phone records established that his cell phone contacted various cell towers throughout the course of the day at each of the locations where evidence attributable to this crime was ultimately found. We also have the defendant's actions of him hurrying and attempting to obtain the deposit from the Comfort Inn when he checked out on the morning of the robbery at approximately 11:30. This is consistent with the attempt to hurry to get to the bank before it closed at noon. After the robbery, the petitioner purchased items from Home Depot, including professional strength goo-off and rubber cleaning gloves. And as the petitioner cleaned the red stain from his car, he told Mitchell that he had robbed a bank. Police later found cleaning gloves, red stain towels, and an empty bottle of soap near the cabin that he had subsequently rented at the Post Motor Inn. The cabin rented by the petitioner also had a red tint on the sink. Forensic testing revealed that the gloves, the towel, and snow in the area of the petitioner's cabin all revealed traces of chemicals used in the bank dye packs. The petitioner was ultimately found at the Super 8 motel, where police secured surveillance footage depicting him removing a large bundle of cash from his pocket when he checked into the motel, and they subsequently seized $70 in cash from the motel, which was also stained red, and subsequently was confirmed to also contain the presence of chemicals used in dye packs. This is all in conjunction with the fact that the manager of the bank subsequently, as he was driving to the bank robbery, observed the petitioner's Cadillac operating erratically on Route 8, which caused him to pay close attention. He was able to note the license plate of the vehicle by talking into his cell phone as he was driving down the highway, and observed the operator of the car throw an object over the roof and into the embankment. Police subsequently discovered that that object was a BB gun, which matched the very type of gun that the petitioner purchased that morning. Despite the fact that the petitioner claimed that he purchased the gun to scare squirrels out of an attic, he failed to explain at all during his habeas testimony whatever happened to the BB gun, if that in fact were the case. Overall, the evidence against the petitioner linking him to this robbery was overwhelming in the context of this case, and he failed to meet his burden of establishing a reasonable probability that the outcome of his trial would have been different if only counsel had offered evidence that his DNA was not found on the BB gun in question. I'd be happy to answer any questions that the court may have. Otherwise, the commissioner would rest on its brief.
Seeing no questions, we'll take that as your argument. And Attorney Mortimer, you have 11 minutes.
Yes, Your Honor. I will be brief with respect to the rebuttal. As indicated at the outset, the state did have a strong case against the petitioner, but at that juncture, given that the petitioner was at trial, defense counsel had an obligation to do everything reasonably possible to provide exculpatory material for the jury's analysis, here palpably available in the form of these DNA reports. So trial counsel's failure to do so in this particular case is particularly unreasonable, in that the argument advanced is that another individual engaged in this conduct, and the petitioner is being charged and potentially convicted of a serious crime that defense counsel submitted was committed by someone else. Now, the fact that there is evidence indicating the presence of other male DNA on the materials that were recovered in this investigation and failing to offer that to the jury, certainly under the circumstances of this case, was prejudicial. In fact, that the state's evidence, although strong, again, largely consistent with the fact that Mr. Eady had committed this offense. And given the confirmation that that was indeed made at the hospital, I do believe this court looks to the record. There is a sufficient time window for Mr. Eady to have been at both the bank and in Bridgeport on that date. So unless there are any additional questions from this court, we respectfully rest on the brief.
So I just want to understand that last bit about Eady. So Eady had time to go to the hospital, go to the bank, and then back to the hospital to pick up his son?
I believe that he would have had sufficient time to have, yes, Your Honor.
Okay, all right. Any other questions? Seeing none, thank you both for participating today and making sure you were on time and all the technology worked. Hopefully we'll see you both in the courtroom soon. I think we're going to start hearings live in May, so maybe we'll see you during the May term. Have a good day. We will stand in recess until 10:30 this morning.
Thank you, Your Honors.